ايه ده؟ Okay, good morning, everybody. This
Good
is
morning, man.
9:30. Yeah, 9:32. I can see you people here. What is this? What is happening? No, I don't want a whiteboard now. Okay, you people are so eager to learn and eager to be in the classroom. Uh, by 9:05, the classroom was already being populated. Yeah, just okay, but it's good. I like your zeal. I like your commitment. So, Adebusola Ajibaye, please mute your mic. Except you want to be our new Emmanuel and Ibukun. It's even high time we got another person. Let's wait for a scapegoat
Ma,
today.
this is not family law, ma. This is thought. It is Omoli
Eh?
and the rest. This is not family law. This is thought. It's
Okay,
Omoli
okay.
and you.
Ibukun and Emmanuel is family law. Yeah.
This
Emmanuel.
one,
Okay, it's you now. Emmanuel. You are the Emmanuel, Abi.
yes, ma.
Ah, I like you.
This
I
one
like
is
the way you
ma.
talk.
This one is Anyoku, and the rest, ma. Not Emmanuel.
Okay, I think Lawrence too is part of it.
Yes, ma. Yes, ma. Yes, ma.
Okay.
Thank you.
Thank you very much. I like the way you chest it very well.
Ma, should I also
Oh,
test my own?
please chest your own.
Yes, ma.
Chiedu.
Yes, ma.
That's nice. Like I said, I really like your class commitments and your zeal. So we started things and we talked about the last two classes. We talked about what were we talking about? Trespass to person. Trespass to persons. Let me quickly do a short recap before we go to interference with goods. Today we are going to be starting a new topic, interference with good. But before we go there, let me quickly do uh, a short recap of what we've done so far. No, this is not what I wanted. Okay. Okay. Mm. So we talked about trespass to person. We said that trespass to person is one of the direct or intentional thoughts. And we said that it involves direct or intentional interference with the person of another. We gave so many examples: striking or putting person in fear of being struck, or unlawful restraining another person, the person's freedom of movement or liberty. We talked about three types. We said assault, battery, and false imprisonment. Assault being putting a person in fear of bodily harm. Battery means any contact, touch, force, or bodily harm. And false imprisonment as the deprivation of personal liberty or movement or liberty, liberty. Any detention, kidnapping, or arrest. We define assault, we talked about so many things, some of the essentials of it, talking as an attempt or threat to apply force or violence to another person with the apparent ability to carry it out. That is, you must have the ability to carry it out. I gave an example. If I say, Anyoko, I'm going to slap you now. I don't have the ability to carry it out because we are talking virtually. And of course, the person must be put in reasonable fear of battery. And we said contact is not necessary. We gave a number of cases. We talked about what needs to be proved, that there was a threat to apply force, that the person was put in reasonable fear of battery. We talked about so many cases, and I think I gave you about 5 cases that you need to go and report and read more. We talked about battery as well. We talked about battery now is the application of force, however slight, to the person of another person, and it has to be a direct and intentional one. We talked about assault. That when you mentioned assault in tort is not the same thing as assault in criminal law, because when you talk of assault in criminal law, you are referring to battery on the tort. So we define battery. We talked about the essentials of it, the unlawful application of force or violence on another person without the person's consent. And however slight the degree of that force is, some form of contact must be, of course, either directly or indirectly. So if I throw a pencil at you, it's a battery, even though my body or my hand did not touch yours. Injury is not necessary, because we talked that battery is actionable per se, unlike when you're going to be dealing with negligence. Negligence as a thought is not actionable per se. But when you are talking of battery or assault, you don't need to establish any injury or loss or damage before you can bring an action on that this. So we talked about the purpose of it, and is to preserve our person, preserve our bodily integrity, our bodily dignity from any unlawful contact, either violent or not. And I think we mentioned that battery needs not to be violent. So if you unlawfully kiss, and you could unlawfully kiss, who is our female scapegoat? It seems our female are well composed. So when Ayaku unlawfully kissed a person, that's battery, even though it's not violent. And I think we talked about the person may be unconscious. You can commit battery against an unconscious person. Person may be sleeping. You can kiss a person sleeping. Or even somebody that is a vegetable in the hospital. We gave so many examples: beating with a stick, knocking a person down, spitting on a person's face, removing a chair under a person, whereby the person falls on the ground. And I think most of us are guilty of this. I can't see any person that will be in the university that at one time or the other in your secondary or primary school, you've not been it's either you are the one that perpetrated it or you've been a victim. The chairs will be removed from under you and you will fall on the ground, yakata, and everybody will start laughing. Okay. What else did we say? That we said that we said need not to be violent. Minimal contact is battery, no matter how minimal the contact is. We talked about, I think the last thing is omission may amount to battery, and I gave the example of Emmanuel riding bicycle and accidentally matching Anyoku's feet and refusing to remove it when Anyoku has called his attention to it that please remove your bicycle, it's hurting my leg. We talked about battery. I think that's all I'll recap on battery. On false imprisonment, we talked that false imprisonment is denying a person freedom of movement or personal liberty without lawful justification. It is a total restraint of a person without lawful justification. It is unlawfully body restraint. And it's also the restraint of another person without his consent and without lawful justification. Any detention, bodily restraint, denial of liberty or freedom of movement of a person in any place and in any form without lawful justification certainly will amount to false imprisonment. So any unlawful bodily restraint or confinement of a person, however short the period of time, is false imprisonment. And we said that it is false because it is not right. And it is a breach of the fundamental right to personal liberty, as guaranteed in Chapter 4 of the 1999 Constitution. So every restraint of liberty of a person is imprisonment. Although, even though it's not within the wall of any common prison or correctional facility. So every confinement of a person in an imprisonment is an imprisonment, whether it's even if it's on a street or the public street, it is false imprisonment. We talked about restraint. There may not be restraint. The use of restraint, as in maybe a chain or something, is not necessary. Then it's not necessary that there was battery. The use of authority, any influence, order, trick, or request is sufficient so long as the person is available to his captor. And the person need not to be aware that he was being detained at the time. So even after you've been released and you now realize that you were detained, you can bring an action in false imprisonment. Of course, we said the purpose of it is to protect the rights to personal liberty and freedom of movement, and to protect the fundamental right to personal liberty, so that it should not be taken away either by the government or any person. We talked about restraint of the person is necessary. For you to say it's a false imprisonment, there must be a restraint, and the restraint must be total. Restraint for the shortest period of time is false imprisonment. So the length of restraint is immaterial, and contact or use of force are not necessary. You need not to be chained or pushed or shoved for there to be false imprisonment. We said also that mere words may not amount to false imprisonment. Knowledge of the plaintiff of the false imprisonment at the time is immaterial, irrelevant. At the time you're being restrained or imprisoned, it's not necessarily that you're aware of it at that time. And he said also that I think unlawful arrest is a trespass to person, which, unless it can be justified, usually renders the tortfeasor liable. Okay. I think we'll call it a day here. And did I do defenses? I think I did. Let me see. I think I did.
You did not finish it, ma.
I didn't finish it. I think I was rushing it, and I thought I finished it. Okay, it's true. Because I don't think I did remedies. Okay, let me start from there. Okay, defenses to trespass to person. I talked about self-defense or justification. I told you to see the case of Turner and MGM Pictures Limited, 1950. Check the case of Lane and Holloway. I've given you that case before. And I think I mentioned that when you are talking of self-defense, it should be reasonable and proportionate. Somebody should not be pushing you or trying to, somebody is touching you with the mere hand. Maybe somebody is beating your shoulder and you brought out a gun and shot the person. That is not proportionate. And like I think I mentioned that when you're talking, the defenses and the remedies I'm giving you covers the entire trespass to person, the assault, the battery, and the false imprisonment. So defenses of property is that the person may commit commensurate or reasonable trespass to person. such as assault, battery, or false imprisonment, in order to protect his property or property of another person which he has a moral or legal obligation to protect. So if Anyoku is trying to protect his property in the warehouse, it's okay, so far it's reasonable and proportionate. Or if Emmanuel is a younger brother that lives with Anyoku and somebody is trying to maybe injure him, he, as the guardian, has that moral obligation to protect Emmanuel. I gave you quite a number of cases. I'm not sure if I've given you, but I think I have. Then the third one I said is consent of the plaintiff. Express or implied consent is it's a common defense. Consent is a defense which is obtained freely in the absence of fraud, trick, deceit, force, duress, or undue influence, etc., etc. So consent is deemed in sports. For example, if you're playing table tennis with somebody and you have to have maybe when you play the egg, it touches the other person, so there is a deemed consent. See the case of Condor and Bassi. Condon is Condon against Bassi, B-A-S-I rather, B-A-S-I, 1985, 2 ER 453. Another one is medical treatment. Medical treatment, medical care, medical surgery. So medical care, patient is usually deemed to have consented to the normal course of treatment for his ailment, except where such treatment is outside the scope of the patient's express or implied consent. So if I go to the doctor and I said, I have a headache, and the doctor, after testing me, decide to operate my tummy for appendix, I don't think that is within the scope of my implied consent or express consent. So consent to medical care is consent to assault, battery, and false imprisonment. But it is not consent to negligent medical treatment. So as a result, treatment or surgical operation carried out in good faith with reasonable skill, knowledge, and care of the benefits for the benefit of the patient is a lawful excuse when it comes to trespass, because these are contacts which are usually for the plaintiff's benefit and for which the plaintiff are given either express or implied consent. So conscious adults who are about to undergo surgery may require to sign further consent forms, etc., which are usually drafted in standard form before the treatment will commence. So there are also exceptions here and there anyway. Adults who require emergency treatment, whether or not they are conscious or deemed to have given implied consent in treatment because of the emergency situation and the need for the doctor to act quickly. So the doctor will just do what is necessary. See the F and Wex Berkshire. I think I've given you this case. Bolam and Frere Hospital, etc. So I think I mentioned that for children under the age of 16, the parents are required to give consent. And there's this case I want to see, Takaro. I can't remember the case now. I'll look for it. Remind me, class rep, where a 14-year-old, the law was saying that he should have asked his consent because he's of age. I think they had to amputate his fingers. Yeah. So generally, where a patient claims that he did not give consent to medical treatment, two possible legal claims may be brought. In instances where the patient claimed that I didn't give consent to medical treatment, so two possible legal claims may be brought, where there was treatment against the patient's will, or where there was a treatment of a different kind, or there was assault and battery. A claimant may claim for trespass to person. So see the case of Chatterton and Gerson. Chatterton and Gerson. Chatterton is spelled Chatterton against Gerson, Gerson. 1981, 1 all ER 257. And also see the case of C in brackets, refusal of medical treatments. So the second one is where the patient was aware of the nature of the treatment, but the doctor fails to give sufficient details or explanation of the risk and side effects. A claim may arise in negligence in that instance, not in a trespass to person. A claim for medical negligence is usually more difficult to prove than a claim to trespass to person. I'm sure you're going to do more of that under negligence. You can see the case of stopping and webs. Stopping is Stubbing against web. Web is Webb. See also the case of Blight and Bloomsbury, HA. The first one, Stubbing and Webb, 1992, QB 196. 1992, QB 197. See also the case of Blight and Bloomsbury. Bloomsbury, HA. Blight is spelled Blythe. And Bloomsbury is Bloomsbury. Blight and Bloomsbury, HA. Blight and Bloomsbury, HA, 1985, AC 871. See also the case of Cedarway. Cedarway is spelled Cedar, as in SIDA. Cedarway. SIDA, then way. Cedarway. Against Bethlehem Royal Hospital. Bethlehem Royal Hospital. Bethlehem Royal Hospital. 1985. AC 871. So a surgery carried out. A surgery carried out by a medical doctor in good faith with reasonable skill, knowledge, and care for the plaintiff is a defense. So accordingly, a surgeon who is operating in an emergency situation on an unconscious patient does not commit battery for several possible reasons. If he's not acting hostilely to the patient, there is implied consent by the patient, and also the defense of emergency or necessity is available to the surgeon. So it's not in every case that the doctor operates. Maybe there was a car accident and the patient was brought in with bleeding, and probably they needed to quickly operate the patient, probably to forestall internal bleeding or something. So you can see the case of Cassidy and Ministry of Health. Cassidy, Cassidy, Cassidy against Ministry of Health, 1951, 1 OER 573. And the defendant, in that case, the employer, don't let me go into it. See also the case of Roe and Minister of Health. Roe as in ROE. However, that is pronounced. ROE against Minister of Health, 1954. QB. Then 1954 QB 66. C Akerele and R. Akerele and R, 1943. 2 all ER 367. Further, CR and Yaro. Yaro Paki as just as pronounced. Yaro YARO Paki PAKI 1955 21 NLR 63. In further to what we're saying, consent is a defense to false imprisonment. Consent, like we've taught in medical care and battery. Consent, which consent is a defense, a total defense. Consent is also a defense to false imprisonment. For instance, when a person who visits a prison impliedly consent to be locked in confinement with the prisoner during the period of the visit. So as many of us that maybe from our churches, from MBA, we go from time to time, we go to the correctional center, I go to the Koyi prison. And during the time you are there, definitely they will lock you up during the visitation. However, fraudulence and so forth usually vitiate such consent. Furthermore, when you talk of consent by a victim, consent by a victim will not excuse the defendant from criminal responsibility. For instance, if he takes the life of a person who consents to the causing of his own death by killing him, so in that instance, consent will not avail you. Also, where a medical doctor negligently certified a person as insane, whereupon she was detained in a mental hospital. In that case, he was held liable for causing a false imprisonment in an insane asylum. See the let me spell it for you. I'm not sure of the pronunciation. The Freival and Deal. The Freival and Deal. The Freival is spelled DE as one word. Frival, another word, FREVILLE. The Freival against Deal. Deal is DILL. Okay. The first is inevitable accident. Inevitable accident. Inevitable accident. So if it's an inevitable accident. So I'm coming, let me clean my glasses. I don't know why it is blurry. Okay, the next one is judicial authority. Judicial authority. Under judicial authority, when we talk of judicial authority, such as a court order, warrant of arrest, prison sentence, and so forth and so on. Lawful arrest may be carried out to somebody who needs to be arrested. Detention may be ordered and punishment may be imposed according to the law. So a judge or magistrate acting within his judicial authority may grant a warrant of arrest, and of course, we've seen it severally. And persons carrying out such an order of arrest may use reasonable force to detain the person named in the warrant. All convicts serving various terms of imprisonment are in their jail or correctional center pursuant to the judicial authority of a judge or a magistrate. You can see the case of Onitiri or Jomo. Onitiri and Ojomo. What happened? One minute. Okay. Onitiri and Ojomo. You can see the case of Onitiri and Ojomo is 1954. 1954. 21 Wow. 21 NLR 19. See also the case of Ajao. Ajao against Alkali, Amodu, and another. Ajao against Alkali, Amodu, against and another. 1960 NNLR 8. See also Egbe or Egbe, I don't know. Egbe or Egbe as pronounced, against Adefarasi. So another one is lawful arrest. Lawful arrest. See statutes, or let me say, see legislation such as the Criminal Code, the Penal Code, the Police Act, etc. Detention, stop and search. So all person owe a duty not to disturb the public peace by committing crime or causing other breaches of peace, etc. So the police have such powers under the Criminal Code Act and the relevant Police Act and every other relevant statute to stop and search a person in public whereby they are reasonably suspicious that a person has committed a crime or may be carrying a stolen, contraband, or prohibited items. So that's why at times you see LDLA, customs, etc. They do that from time to time. So the police and other law enforcement agents and private citizens have powers to make arrests with or without a warrant, as the case may be. We've talked about having a warrant of arrest. But at times there is no need for warrant of arrest if there is a high suspicion of crime. So a lawful arrest, detention, or stopping and search and so forth are defenses to assault, battery, and false imprisonment. For that, you can see Murray and Minister of Defense. I think I'm not sure if I've given it, but I think I have. Murray against Minister of Defense. Murray is Murray, and Minister of Defense, 1988. 2 all ER 421. The requirements of a lawful arrest and stop and search may include so for it to be lawful, some of the requirements means that an arrest must be within the powers granted by a relevant statute. So if you are a policeman and the arrest is not within that power, you are operating outside that power. Then secondly, there must be a reasonable suspicion on the part of the arrestor or person making the arrest. And the third one is that the use of reasonable or proportionate force. So in the course of probably trying to restrain the person that you want to arrest, where you can use reasonable and proportionate force. So the situation where you see the policeman shooting somebody because there's a suspicion is not acceptable, except you see the person as a gun. So probably you're using a reasonable and proportionate amount. No, so we ask ourselves, what amounts to reasonable suspicion? This is highly objective. A suspicion is objective, and it depends on the circumstances of or fact of each case. You cannot say it's either here nor there. It's highly subjective, rather. So you can see the case of Olgate Mohammed. Holgate is Holgate, Holgate Mohammed. against Duke. Holgate Mohammed against Duke. 1984, 2 WLR 660. Now, in that case, in the course of criminal investigation, the police especially can, with the consent of a suspect or the permission of a senior police officer, take bodily samples of the suspect, such as hair, finger, nail, blood, body fluid, etc., for analysis in the course of criminal investigation. At times, particularly outside the country, where the police will stop you and it will tell you to breathe in order to check your alcohol level. So, therefore, the police have wide powers, both at common law and under the statute, to arrest persons they reasonably suspect or they have the suspicion that he has committed a crime. Also, a private person or a group may effect arrest as provided under law in relevant circumstances and hand over the person to the police. On Saturday, I think, or early on Sunday, I was watching, all these short reels being sent from one WhatsApp group to the other. I think I saw one in which a man was being arrested or detained. In fact, it was changed down by a local community in Ikorodu. The allegation is that the man, the community, they have a school. I think it's a community school. So the man was employed as security man, but the man himself was the one stealing, and I think he wanted to kidnap a student. So when they apprehended him, they chained him down, and even in Nigeria, they beat him, but that beating was not obvious. But they chained him down, and they were saying that they contacted the commissioner of police in area F or something to come and pick up the man. So that's a good example where a private person or a group of private person can effect arrest. So provided you are doing it within a reasonable range. Imagine picking that person up and using cutlasses to beat him or to harm him. That is not acceptable. A defender who is acting under the criminal law is protected. Now, a plea of reasonable and probable cause may be made. A policeman who mistakenly arrests an innocent person is not liable for wrongful arrest, so long as he has reasonable ground for suspicion of the innocent person at the time of the arrest. And this is the ground on which many of the police officers they hide under. When they see a young man within the age of maybe 16 and 40, and they see dada hair on him, as in dreadlock, or they see tattoo on his body, they just think the person is a Yahoo person or somebody who is criminally minded. However, in false imprisonment, the defendant has the burden of proving that there was reasonable cause for the arrest or the detention of the plaintiff. I have a word. The boy Toby has traveled out of Nigeria now. A young boy, very, very brilliant. I think he finished with a first class from Covenant, and he did make engine. When he finished, he got a good job immediately. Got a job at, I think, Mikano. He's from a normal background like you and I are from. So, and because of that, as a young man, he got a good job. After 2, 3, 4, 5 months, he was able to pull resources together. He bought a very small, beautiful car. And it's averagely tall guy. He's like 6-footer, handsome young boy, but very, very quiet, not outgoing, very introversion. He's an introvert. But every time he's going to work, or let me say, 90% of the time he's going to work every morning. There are 2 police stations on his way to work. So, at times, those police guys, they will mount a stop and search around. I can assure you at least 3 times in a week or twice in a week, they will stop him. They will stop him. They will search. They will do everything. He's like, there are times he will call me or his mom will call me from clinic. Mama, they will just stop him. The policemen of our time in Nigeria, they can't reasonably think that any young man can walk and have a car. That young person must be a Yahoo boy. That's just their own sorry state of mind, so to speak. If it became so, at times I'll be coming to work. There was a day I was on Third Mainland Bridge. They look at his paper. He didn't buy a Tokumbo. He bought a car. A friend of his too was traveling out, so he bought a car, so a fairly used car, but he maintained it very well. So they will look at his document. They will say, why did he do this? Why? They will scrutinize it. In fact, there was a day when they apprehended him, they took him to the station. That was one of the peak of it. They took him to the station. They told him to undress. They were looking at his body, looking for tattoo. And this young boy is a Christian, a very easygoing. He plays the keyboard, but he's a very huge and lanky 6-footer, very handsome and young. They will search him. So on one particular day, we were in the church, and it was on a Sunday morning. The mom just came to whisper to me, they said that the affidavits that he used, the affidavits for the change of ownership is kiniko. I said, today is the last. I called on two other senior lawyers. And my church is a family church. We called on this, called on that. When we got there, we were in about 3 vehicles. We'll be up to 21 of us. When the boy, the boy is a very shy. When he saw us, the boy was scared. Just because of me. The boy already, the Yorubas, they want to kolaya. If by the time you get to law school, you understand affidavit. Affidavit is not, it's not compulsory you do it. There are so many places you can do an affidavit. Like I told you earlier, I think I mentioned it maybe in this class or in the family law class. I'm a notary public, so I do affidavit for people. A JP can do affidavit. You can do it in the Ministry of Justice. There are people there. You can do it in the High Court. But police people with their half education and semi-literacy, they have a stereotype of affidavit somewhere. So they are told the boy that his affidavit is wrong, he's fake. They showed him the one they are used to, maybe the one from the courts, that is a normal affidavit. So the boy already had accepted that it's true. So they've told him to go and pay 25,000 naira to one POS, the way they operate. So when the boy saw us, the boy called his mom, Mommy, you see, they've showed me it is true. I'm in contravention of the law. That my affidavit is not supposed to be. The affidavit he did was from a JP, Ministry of Justice. And but they are used to only the High Court. I said, no way, let's see. So all of us, we now went to those 3 police officers. They were scared. I started recording them. We're talking, I said, we told them, you people, look at this boy very well. Today is the last day. You should stop him. But the fact that the boy is an easygoing, he would just, at times, to give them 5,000. The fact that you've harassed him so much does not mean that he's a boy without people. Meanwhile, I'd called a family friend of mine who is a deputy AIG for this zone. I've called her. We shall threaten them that next time you stop this boy, we now have to educate them on affidavit. I brought out my seal and everything that I am a notary public. This is another kind of affidavit. They were scared, so scared they were now apologizing. They say, the way they would talk is good. All of us will learn. You two, you've taught us. We are learning. They were just looking for so many things. I was even satisfied, but another fellow and a more senior friend, no, not even senior, come to think of it, he's just older in age than I, guys, he said no, that they want to know who said he should pay 25,000. They started bleeding. They asked him, Toby, have you paid any money? We didn't check it. They were just apologizing. Eventually, they gave us their numbers. They gave the boy the number that once anybody should stop him again, he should call them. They will do this, they will do that. Before, while we were talking, there's another lady in our church. She's a very senior member, managerial something in LASMA. She too, she came with her team. They came. That day, the police station, they wanted to just die. They just wanted to die because we have to tell them that enough is enough. So that's just a digression. Talking about high suspicion of the person has committed a crime, being subjective. Our police people in Nigeria, particularly in Lagos, they just have one pointer, and that pointer is if you're a young man, you are into a good car, you must be a Yahoo boy, or you must be a fraudster, or you must be a ritualist. Once you have dada on your head, you must be a Yahoo person or a ritualist. Once you are good looking and you have a good life as a young person, you must be, because their worldview and the background they are coming from is so bad that they themselves, they are victims. So they can't see any person, a young boy of 23, 24, 25. Toby is actually 26 anyway. So they can't imagine a young man having that kind of, and the car is just, it's just Camry. It's not Camry. I think it's a Toyota. It's not big that it's a Toyota, not the small Toyota, but just a normal, reasonable Toyota salon that a young man can have. Like I told you, it's not a new car, but when he bought it, he renovated it, he did it very well, resprayed it, and okay. So in the case in Christie and Lanchinski, in Christie, let me spell it. In Christie and Lanchinski, Christie is CHRISTEIE, Christie, and Lanchinski, Lanchinski, LEACHINSKY, 1943 AC 573. The defendant's appellant police officer, without warrant arrested the plaintiff respondent for unlawful possession of a number of bales of clothes. They had reasonable grounds for thinking that the clothes were stolen, but they did not disclose to the appellant the reason for arresting him as required by law. On appeal, the House of Lords held that the arrest was unlawful because they didn't disclose to him. See also Brogan and UK. Brogan, BROGAN, against UK. Brogan and UK, 1989, 2 EHRR 117. However, a person who is authorized by law to use force may be personally liable for any excessive act he committed in the course of duty, depending on the nature and quality of the act. Also, an erroneous belief in a power of arrest will not excuse an unlawful arrest. Damage for battery, false imprisonment, and so forth will lie. In the case of Older and Chief Constable of Lancashire, Older as in HOLDER, against Chief Constable of Lancashire, LACANSHIRE, 1986, 3 all ER 836. The court held that there was a false imprisonment of the plaintiff, as the police officer had no reasonable ground for suspicion of the plaintiff at the time of the arrest. So another one is statutory or lawful authority, another defense. Trespass to person may be excused where it is committed in preservation of society. See 1999 Constitution, see Section 33(2), Section 34(2), Section 35, Section 41, 44, and 45. So trespass person may be excused where it is committed in preservation of a society. See 1999 Constitution, see Section 33(2), Section 34(2), Section 35, Section 41, Section 44, and Section 45. Look at the case of Liverdage and Anderson. Liverdage and Anderson. Liverdage is spelled Livers, Liversdige, Dige. Livers, Dige, and Anderson, Anderson, 1942 AC 206. See also Brogan and UK. I think I've given you that case earlier in the class. Under any enabling statute, for instance, under the Nigerian Constitution, if there is that authorization, in Nigeria, a person may be lawfully deprived of his personal liberty or his fundamental rights, otherwise restricted in certain circumstances. Example is in connection with a criminal case by lawful arrest or in execution of order of a court, in connection with infectious diseases or unsigned mind. Imagine the time of COVID. Thank God for somebody like a late Dr. What's her name? You all know her. The name, I can't easily recall it now, but thank God for her, who restricted the crazy Siwa, who came from Sierra Leone or is it Liberia, that wanted to come and infect everybody in Nigeria. So if there is a suspicion of infectious diseases, in a connection, okay, I've told you, in connecting with immigration law, also there could be lawful restraint. In connection with education and welfare of an infant or apprentice who are minors, that one is also allowed. So number nine, a defense is reasonable chastisement in exercise of parental or other authority. So when there's a reasonable chastisement in exercise, when you're exercising your parental or guardianship role or other authority, as a matter of tradition and law, parents have rights to administer reasonable punishment or chastisement as a discipline in order to ensure the proper upbringing of a child. Though we have to be mindful, I'm just thinking of it now, in our schools, in our colleges, I think there are policies about corporal punishment. You have to put that in mind. However, the punishment of a naughty or rude child may be reasonable, must be reasonable. Otherwise, the chastisement may amount to thought or crime. Nowadays, because of parental objection to smacking or caning of a child, the practice is no longer permitted in schools, like I said, whether public or private. However, the Parents and Teachers Association may permit teachers to administer reasonable chastisements of children, as such do not amount to inhuman treatment of children. In some schools, they allow only maybe the principal alone to do the chastisement of the child. And it's not a breach of the fundamental right or dignity of a human being as guaranteed under Section 34 of the 1999 Constitution. We can see the case of Ekeogu and Aliri. Ekeogu and Aliri. Ekeogu is Akeogu against Aliri. Aliri. Ekeogu and Aliri. 1991, 3 Nigeria Weekly Law Report, Part 179, page 258. It's a Supreme Court case. Therefore, a parent or other person in local parentis of a child. I don't know if I'm in local parentis. Yeah, I'm in local parentis, but I don't know even if I'm permitted to be spanking you people, so that I can get a cane and beat Emmanuel, Lanyogu, Lawrence, and their cohorts. So person also in local parentis of a ward or pupil may, in exercise of such parental authority or similar authority, can administer lawful and reasonable chastisement and punish or discipline a child in order to correct him or her. Note that the amount of punishment administered must, however, be reasonable in the circumstances and the short of criminal offenses of cruelty to a child. So if you are administering reasonable chastisement, it must not be cruel, it must not be criminal. A teacher may exercise authority or in authority, administer lawful and reasonable chastisement to bring up pupils as disciplined. It must be responsible and law-abiding citizens. This authority was normally implied by the mere sending of a child to the school. So you've given the concept that the teacher can send your child to a naughty corner or tell him to stand up when he has done something naughty. But however, nowadays, the authority of a teacher to discipline a child depends more on the position of the government and policy and the society, like I said. So also in aircraft or in the ship, the captain is reasonably responsible to maintain order for the safety of the trip. You know, the captain on the aircraft, as many of us have been in aircraft, the captain is the chief, I'll say the chief security officer, and can therefore exercise such authority as he may deem necessary to preserve life and property in the course of the journey. In the case of Hook and Conrad Steam Ship Company Limited, I want to finish this today and start the other one. The plaintiff, Hook, as in Hook, and Conrad, Cunard, Hook and Conrad Steamships, Steam as in Steamship Company Limited, 1953, 1 all ER 1051. In that case, the plaintiff was a steward in the defendant's company's cruise line. Following a complaint by the parents of a child on the board of the ship, the captain of the ship had the plaintiff confined for a night in a cabin and thereafter restricted his movements on the ship. He was later sacked and fully paid off. The said complaint made by the parents were inconsistent and uncorroborated. There was ground for casting the slightest aspersion on the plaintiff's character. The plaintiff stood for false imprisonment. The court held that the defendant's company was liable for false imprisonment and aggravated damage were awarded to him. Akinyemi Precious. Akinyemi Precious. Yeah, the next. Akinyemi Precious, can you mute? I can hear you. Can you mute yourself? Akinyemi Precious. Akinyemi Precious. Akinyemi Precious. Mute yourself. Akinyemi Precious. Akinyemi Precious.
Oh, yeah.
I'm going to sanction Akinyemi Precious. Somebody should tell Akinyemi Precious. Okay. I've noted you, Akinyemi Precious. You just logged into the class. You are not here, and you are carrying out your business. Akinyemi Precious, Akindeji. So the last one is necessity. This is a real defense.
I'm trying to mute.
Akinyemi, I've noted you, Akinyemi Precious, Akindeji. You are disturbing my class. APA, Akinyemi Precious, Akindeji. APA, you are disturbing my class. So necessity is another defense. It's a real defense.
I'm sorry, ma, you committed by mistake.
That mistake, it's not a defense. It's not a defense. Oh, yeah, mute yourself. Okay. He has not muted himself again. Aderi Kola too has, okay. Yeah, Aisha has muted. Akinyemi Precious refused to mute himself again. Okay, so I said necessity is a real defense. A defense may show that he committed a trespass to person to avoid a greater harm, such as forcefully feeding a person to preserve the person's life. This was the situation in the case of Lee and Gladstone. So I don't know. Lee and Gladstone is spelled Leigh. Again, Gladstone as pronounced. So let's quickly look at remedies. Number one, declaratory judgment. Declaratory judgment. A claimant may get a declaratory judgment declaring the right of the person to enjoy the fundamental right to dignity of human person right to personal liberty, right to freedom of movement, and so forth and so on, as guaranteed under the Nigerian Constitution. You can see the case of Shugaba. I keep mentioning Shugaba. It's a case for you to read. A declaratory judgment. In fact, this Shugaba case, the irony of it is that it's one of the earliest cases I knew as a young child. My parents used to mention it, Shugaba, Shugaba. You need to read the case. It's very interesting. Where there was a deportation saying that man is not in Nigeria. They just deported him to Chad. So Shugaba, Internal Affairs, Minister of Internal Affairs, I've mentioned it several. Look at it. Look at Iyere and Duro. Iyere, as pronounced, Iyere and Duro. Or Duro, 1986, 5 NWLR, part 44, page 665. Look at Amakiri and Iwowari. Amakiri as pronounced and Iwowari, 1974, 1 RSLR 5. See Alabo and Boyles. Alabo is ALABOA. Alabo and Boyles. BOYES. Give me a minute, please. Okay, so I gave you Dele Giwa and IGP is another one under this. I gave you earlier on. Soji Omotunde and AG Federation. So the second remedy is injunction. Injunction. Then the third one is binding over to keep
Ma.
the. Okay. What's it?
Sorry, I didn't get the first remedy.
I said the first remedy is a declaratory judgment. Declaratory judgment.
Thank you, ma.
Okay. So I told you the first one is declaratory judgment. Declaratory judgment. If you read Shugaba's case, you will understand further. The second one is injunction. The third one is binding over to keep the peace for a specified period. This one you may not really understand, but let me just give a small binding over, you go to court for a binding over. I've been involved in a couple of one before. There was this one in which a community, they're fighting over a property. The case is in the High Court, but there was an action was brought for binding over to keep peace for a specific period of time during the duration of that. Before the court will, for instance, you're fighting over a land and there's been violence, counter violence, and you can bring an action for binding over that. The land, there will be no more quarrel or violence pending the period when the court will make will give the land to determine the ownership of that land, so to speak. It's just an example. So award of damages is the fourth one. And the fifth one is a writ of habeas corpus. Writ of habeas corpus, C. Agbadi and COP, 1969, 1 NMLR 137, C. Taisholari and IGP. It's an unreported case. Then number 6, I won't go. Number 6 is apology. C. Delegiwa and IGP. Then number 7, escape from unlawful custody or kidnap. Escape, if you escape, is a remedy. Then number 8, self-defense. Okay. I think I will stop here so that I can start the next topic. Motunrayo, you are raising your hand. Quickly, I'll give only Motunrayo the right to ask questions, because many times when I give that privilege or that opportunity, other people will start
Yeah.
raising up
Good
their
morning,
hands.
ma'am.
Motunrayo, quickly ask your good morning,
Yeah, I'm
ma.
sorry. I just want to
I will take you, Daniela.
go back to assault. The case of Tubabal and Savage and Aaron Light, the cases are contradictory. So if you have a scenario, say in our exam or test, if you have a scenario whereby we are presented with words like an action that will necessarily amount to an assault can be negated by words. So I think that's the gist of Tubabal and Savage and Aaron Light. So how do we now reconcile the
You
cases,
reconcile
and
it
what would our
based on the
conclusion
fact
be?
of each case now. For instance, what may negate it? If I tell you that, if I look at you, that Turayo, if not because you're a good student, I will have slapped. I raise my hand and look at you, that Turayo, and I'm with you physically. That if not because you're a good student, I will have slapped you. Or if I say, Turayo, if not because your mom is a good woman, I will have slapped you. And I'm raising my hand, or I lift up my cane. What will you do? What will you say? My word has negated it. 1 minute. Okay, so that's that. Okay. I think I'll just leave it as it is now and quickly start the other. We need to move. I'll start my interference with chattel because I need to introduce that topic. Interference with goods. Interference with 1 minute. Okay, interference with goods. We talked about trespass. We said we're going to be treating three areas under trespass. We've done trespass to person, and under it we talked about assault, we talked about false imprisonment, we talked about battery. Now, the second one we're going to be talking about, the second kind of trespass, is what we call interference with goods. And the third one will be trespass to land. Now, trespass to land, I think it's Dr. Adedokun that will take you on that. I will take you on interference with goods. It's a form of trespass. Sorry, I have to quickly attend to something very urgent. Now, so when we talk of interference with goods, we're going to be talking about it under 3 subheading as well. Interference with goods. When you talk of goods or interference with chattel, you can talk about it, goods or chattel, it means the same thing. So when we say interference with chattel, we ask ourselves first, what do we mean by chattel? What do we mean by chattel? Interference with goods. Now, a chattel is any property. A chattel is any property other than land, an immovable property. I don't know if you understand. Let me say it again. A chattel is any property other than land, an immovable property. So it is not land or immovable property, and it is not a person, your body, like we've done under trespass to person. A chattel is any immovable property. The word chattel means any article, good or goods or personal property other than land and immovable property. Examples of chattel or goods are innumerable. There are so many. A chattel is any movable thing which is capable of being owned, possessed, or controlled other than human beings, land, and immovable properties. Example of chattel includes cars, furniture, animals, vessel, aircraft, seacraft, anything whatsoever which is movable and capable of being owned. Indeed, the list of it is enormous and cannot be exhausted. So now the purpose of the thought of this interference with goods, we've talked about interference with person, that is trespass to person. We've talked about it. Now, the purpose, and we said the purpose of interference with person then, or trespass to person, is that you can keep your bodily integrity. You can keep your right to liberty so that nobody will violate you, nobody will treat you shabbily, nobody will forcefully restrain you. But the purpose of interference with good is that people's property or chattel or personal property, whatever it is, should be protected. And there should be no illegal, unjustifiable interference with it. So the thought of interference would protect all chattel, all goods or personal properties of the person who has title or possession by prohibiting all interference without legal justification. The thought of interference would protect the right of ownership or possession of a chattel from all wrongful interferences. Therefore, the thought of interference would protect the chattel, goods and all personal property of the person who has title, possession, or right to immediate possession against anybody meddling with it, damaging, destruction, conversion, detention, or any interference whatsoever by any other person without lawful justification. Now, the three forms of interference with goods that we're going to be talking about, which are actionable per se, upon commission or occurrence, without the plaintiff having to prove damages or damage. I'll explain that further. We're going to, under interference with goods, we're going to be dealing with three forms. And I'm saying before we start taking each of them, I'm saying that the three forms of interference with goods are actionable per se. Upon commission, upon the slightest commission, they're actionable per se. You don't need to prove loss, injury, or damage. In the case of David's Lagos City Center, Council rather, Davies against Lagos City Council, 1973, 10 CCHCJ 151. Adefarasin J then says that the plaintiff is entitled to succeed in trespass. There may be a trespass without infliction of any material damage by a mere taking or transportation. In my view, the seizure of the plaintiff's vehicle without just cause is a wrongful act, on account of which all the defendants taking part in it are jointly and severally liable. So what the case is buttressing the fact also that you don't need to have suffered any loss, injury, or damage before you can bring an action in interference with chattel. It's actionable per se. Although trespass to chattel is actionable per se, it is, however, it is not a strict liability tort. Furthermore, where a special damages has been done to a chattel, a plaintiff is entitled to prove it and recover damage for it as the case may be. So let's talk about the forms of interference with goods. In Nigeria, the total of trespass interference with goods is made up of three types. The first one is what we call trespass to chattel per se. Trespass to chattel. The second one is what we call conversion. Conversion. And the third one is what we call detenue. 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 So we're going to start each. Trespass to person, trespass to chattel rather, conversion, and detenue. These are the three forms we're going to be dealing with. What says the time? 6 more minutes. 6 more minutes. Can I? Okay, let me start it. Let me start it even with 2 minutes and whatever I'm able to say. Now, when you talk of trespass to chattel is any direct and unlawful interference with a chattel in the possession of another person. Trespass to chattel is any direct and unlawful interference with a chattel in the possession of another person. It is the intentional or negligent interference with the possession of the chattel of another person. In other words, trespass to chattel is any direct interference with a personal property in the possession of another person without lawful justification. So if you touch my laptop, if you touch anything belonging to me, Akindeji, Precious, who will have committed the trespass to chattel. The interference must be direct and wrongful. Therefore, the mere touching of a chattel without causing any harm to it may, in appropriate circumstances, be actionable and entitle the plaintiff to get nominal damages. So even if you touch without consent or without lawful justification, that one action can be brought against you. So you don't need to cause damage to any of the property you're touching before there will be a trespass to chattel. So when you talk of trespass to chattel, it's designed to protect the following interests in personal property. Number one, right of retaining one's chattel. It's meant to protect it. Number two, it's meant to protection of the physical condition of your chattel. Protecting the physical condition of your chattel. Then number three, protection of the chattel against unlawful interference or meddling by any other person. So the trespass to chattel is designed to protect the following interests. Number one, rights of retaining one's chattel. Number two, protection of the physical condition of the chattel. And number three, protection of the chattel against unlawful interference or meddling. And I think with this, I am going to bring the class to a close for today. By God's grace, on Wednesday, we'll come up and we'll continue. And we need to rush more. We need to fast track our learning so that we can cover what we need to cover. Thank you very much. Have a blessed week. Have a blessed month. And may your month be fruitful to you in Jesus' name.
Amen.
All right.
Amen.
Thank you
Thank you very much.